and welcome back to our channel. My name is AYUSH Kumar Singh. I am a legal intern in LEXIS and Company. So in this video, we are going to have a discussion on doctrine of severability in different countries. So starting from the constitutional meaning, if an offending and inappropriate provision of a statutory legislation can be separated from that portion of the statutes which is deemed to be a valid and constitutional in nature, then only that part will which is offending and repugnant shall be declared as being void, and not the entire statute itself. So basically, the doctrine of severability is a common law in UK, US, Malaysia, and India, but in Australia it's a primacy of Parliament. So, starting from UK, the doctrine of severability in UK has been originated in the case named Nelford versus Maxim Netfeld Gun and Ammunition Company Limited, 1894. The principle of restrictive trade practice utilized as against the concept of fair competition. First recorded case in English history ever known to apply this judicial doctrine to a case. So now doctrine of severability in USA. It was applied in the case of United States versus Rees 1876 and restrained in Champlain Refining Co. versus Corporate Co. of Oakham 1932. The concept of successful separation of the void and statutory legislation from the invalid part without causing the lateral, that is void statute, from being dependent on the former's valid statutes. Now let's see the case of Atrio versus Planned Parenthood of New England. The court laid down three principles of severability. First, we try not to nullify more of a legislation work than it is necessary. Second, we retrain ourselves from rewriting state laws to convert it to constitutional requirement, even as we steve or slave it. Third, a court cannot use its remedial power to circumvent the intent of the legislation. So now coming on the doctrine of severability in Australia. Doctrine written into law under section 15A of the Act Interpretation Act 1901 limit jurisdiction of courts. Limitation 1. If there are number of possible ways to read down a provision of general application, it will not be read so down unless the Parliament indicates with supporting head of the legislative power it is relied on. Limitation 2. A provision of a general application will not be read down unless Parliament indicates an interaction that the provisions is to have a destructive operation. Test of resourceability such as restrictions on trade. So now lastly coming on the doctrine of severability in India. Article 13 clause 1. All laws in force or in the territory of India immediately before commencement of this constitution is so far as they are inconsistent with the provisions of this part shall to the extent of such inconsistency to void. Article 13 clause 2. The state shall not make any laws which take away abridge the right conferred by this part. And Article 13 clause 2. The state shall not make any law which takes away or abridge the rights conferred by part 3, and any law made in contravention of this clause shall to the extent of the contravention be void. Article 13 clause 3b includes law passed or made by the legislation or other competent authority in the territory of India before the commencement of the constitution, not previously repealed, including customs and usages, and also the laws passed by the British Parliament and applicable. So there is a case of RMDC versus Union of India. Intention of the legislature will determine whether the valid part of a statute is separable from the invalid part. If a valid and invalid provisions are so inextricably mixed up that they cannot be separated from another, then invalidity of a portion must result in the invalidity of the act as its entity. On the other hand, if they are not distinct and separated, that after seeking out what is invalid, what remains is itself a complete code independent of the rest, then it will be upheld, notwithstanding that the rest has become unforeseeable. So I hope you find the video informative. So please like, share and subscribe.